Well, thank you very much, Zano, for that very kind introduction, and thank you to all the organisers for inviting me to speak to you today. Before I get into my topic, let me make two introductory remarks. First of all, I'm most impressed that in Latvia you can have a seminar like this that is so well attended by judges at all levels. I cannot think of a comparable event in my country on intellectual property that has been or would be so well attended by judges at all levels. We do, of course, have lots of events on intellectual property, but they only get attended by a relative minority of the judiciary. So you're doing very well. I'm most impressed. The other thing, which I cannot help observing, is the gender balance. This is another area where you're way ahead of us in the United Kingdom. At the lower levels of our judiciary, after a lot of effort, we've now got to the point where we've got a 50-50 gender balance, and we've also got a healthy representation of ethnic minorities. But I'm afraid to say that the further up our system you go, the more male and the more white it gets. And so at the Court of Appeal level, we're still under 30% female, I'm afraid, and a very small minority ethnic representation. The Supreme Court was delighted last year when they managed to hit 25% female. But I regret to tell you that next year it's going to go backwards because whereas currently we have 3 out of 12 women in the Supreme Court, 2 of those women are shortly to retire and they're being replaced by men. So next year we'll go back to 1 woman out of 12. Not good. There we go. Progress is slow. So I'm going to be talking to you on 2 topics today, and this afternoon, or shortly before lunch rather, I'm going to be talking to you about website blocking, and I'll pick up some of the points that Thomas Dillon has just made to you. But first, financial remedies for intellectual property right infringements. Now, this is quite a large topic, and one thing that is worth pointing out at the outset, which I'm sure is obvious to most of you, is that when we talk about financial remedies for intellectual property right infringement, we're talking about an amalgam of different subjects. So we're talking partly about substantive law, we're talking partly about procedural law, we're talking partly about evidence, and various other factors enter into the equation. And so this is therefore a large topic. Another point to bear in mind is that while there's a certain degree of commonality across all intellectual property rights when it comes to financial remedies, the further you dig down into the detail, the more you find small differences emerging. So what I'm going to be saying to you is broadly true, whether we're speaking about patents, trademarks, copyrights, design rights, even trade secrets. Once you get down into more detailed levels, then you would start to find a few differences emerging. But I'm going to be concentrating on the broad picture. So, the starting point under our system is to appreciate that we have 2 different forms of financial remedy. And we regard it as being very important to distinguish between these 2 different forms of financial remedy, both from a jurisprudential point of view and from a practical point of view. And just to anticipate a point that I'm going to come back to a little later, one of the problems that we have when we look at Article 13 of the EU IP Enforcement Directive is that to our eyes, it is an amalgam of these 2 different remedies. And we regard that as being rather problematic, and I'll come back to that. So what are these 2 different remedies? Firstly, damages. Secondly, what we call an account of profits. Now, these are conceptually fundamentally different things. Damages are compensatory. They are to repair the harm that the right owner has sustained as a result of the infringement. An account of profits is restitutionary. It is a requirement for the infringer to disgorge the benefits that the infringer has obtained through the infringement. So they're conceptually quite distinct remedies, and I'll come back to that a little more. Now, as to the question of the choice of remedy, that is for the right holder. If you are a right holder, you've brought a claim for intellectual property right infringement, you've been successful in establishing liability on the part of the defendant, you then have a choice as to which of these two remedies you want to have. And of course, what the right holder usually wants is the remedy that will be most beneficial to the right holder, which is to say, the remedy that will give them the largest amount of money. And so, from the right holder's perspective, when they are required to choose between the financial remedy that they're going to elect for, they obviously don't want to have to make that election blind and in the dark as to what they might recover, financially speaking. And so, before they have to make that election, the defendant is required to provide some basic financial information. And typically what will be required at that stage is that the defendant discloses three broad areas of financial information. Firstly, the defendant must disclose the number of infringing products that have been made and or sold. Secondly, the sums of money that have been received or are receivable in the future by the defendant. And thirdly, an estimate of the costs incurred by the defendant in making or selling the infringing products with an explanation of how that estimate is made. And so once the defendant has provided that basic financial information, then the claimant, the right holder, will be in a position to make a calculation as to, broadly speaking, which remedy they think is likely to be most beneficial, and they can choose which remedy they want to go for. So, let's look a little further at the question of damages. So the basic principle is very clear and very simply stated. As I said to you before, that is that the claimant is entitled to compensation for the loss suffered by the claimant as a result of the infringement. And in general, there are three basic methods of assessing such damages in intellectual property cases. Firstly, by calculating damages representing the claimant's lost profits, where the claimant is a manufacturer and or supplier of goods protected by the relevant intellectual property right. So if we have, for example, a patent which protects a particular product, and the claimant itself manufactures goods that are protected by that patent and makes profits, and as a result of the infringement, they've lost sales and therefore lost profits, then you can claim on this basis. So a very typical example of this is where we're talking about a patented pharmaceutical product. And the plaintiff, the claimant patentee, sells that particular pharmaceutical product, and then someone comes along and infringes the patent by selling the same product, and therefore there's a loss of sales and a consequential loss of profits, so the patentee claims that loss of profits. Now, that method of assessment involves two basic questions. Firstly, to determine what sales have been lost by the claimant as a result of the infringement. So that's a question of causation, and it's really primarily a question of evidence. I'll come back to that point in a moment. Secondly, once we've calculated what sales have been lost by the claimant, the next question is, well, what would have been the claimant's profit on such sales, and therefore what profits they've lost as a result of losing the sales? Now, coming back to that first question, what sales have been lost by the right holder as a result of the infringement? This is going to vary depending on the nature of the case. So, coming back to the example I gave you before of a patented pharmaceutical product, in a case like that, it's quite likely that every sale that's made by an infringer will be a sale lost to the claimant, because it's a true monopoly over the product. I'm envisaging the case where we've got a patent for a particular compound, a particular medicine. And in that scenario, the effect of the patent is to give you a true monopoly, and therefore if there's an invasion of that monopoly by the infringer, you can quite readily reach the conclusion that every sale by the defendant is a sale lost to the claimant. So it's 1 for 1. But by contrast, if you take another type of case, let's say trademark infringement, and you have a situation where the nature of the infringement is that the defendant is selling goods under a confusingly similar trademark. So not the identical trademark, but one that is confusingly similar. Now, typically, if you have sales of products under confusingly similar trademarks, it's not the case that all members of the public will be confused. Typically, what you would find in such a scenario is that some members of the public will spot that it's different and not be confused, whereas other members of the public will fail to notice the difference and will be confused. So you might conclude that, just to take a hypothetical example, maybe 25% of members of the public are confused. Now, that's plenty to establish a claim for trademark infringement. The basic rule for trademark infringement is that if there is any substantial degree of confusion of members of the public, that's enough. But when we come to assessment of damages, what that figure tells you is that not all of the defendant's infringing sales are causative of damage to the trademark holder. On the contrary, if it's a 25% rate of confusion, what that tells you is that 75% of the defendant's sales cause the trademark owner no damage at all. So in that scenario, it's not 1 for 1. On the contrary, it's a ratio of 1 to 4. So that investigation will first of all involve an inquiry into the nature of the right that's been infringed. Is it a true monopoly, or is it only a partial monopoly? And the extent to which the defendant's activities amount to an infringement, and as a matter of causation, how much harm is that causing the right owner in terms of loss of sales? And it can be quite difficult to estimate the proportion of sales that are lost in the more tricky types of cases like trademark infringement based on confusing similarity. Other cases like patent infringement for pharmaceuticals, it's much easier, as I said. Then you come on to the financial question of what is the claimant's lost profit on those sales. And that's again, very much a question of financial evidence, and I'll explain a bit more about that in a moment. So let's move on to the second method of calculation. This will be relevant where the claimant is not a manufacturer or supplier of protected goods, but instead its business model is one of granting licenses to third parties. So this would be very common, for example, in the copyright field. A lot of exploitation of copyright works is carried out by licensing. So a classic example would be book publishing, authors typically in the book field don't publish their own books. Of course, these days some of them do on the internet. Self-publishing is a possible business model. But even now, most authors will exploit their copyrights by licensing book publishers to exploit their copyrights around the world. And there are all kinds of other scenarios where intellectual property rights are exploited through granting licenses to third parties. Now, if that's the claimant's business model, then typically the way in which you will assess damages is by looking to see what royalties the claimant has lost as a result of the infringing activity. So again, you get into a question of, first of all, well, what's the, in terms of causation, the degree of the loss, and then the financial aspect, what royalties have actually been lost as a result. Then the third method is, well, what if you have a claimant who can't prove that he's lost sales because he's not a manufacturer, and also can't prove that he's lost sales because he's lost royalties because there's no relevant license. And that is a surprisingly common scenario. It is quite curious and interesting that the cases that come to court, it's actually not at all uncommon to find a situation in which the claimant is not a manufacturer or supplier of the protected goods and doesn't have a relevant license, maybe because the infringer is operating in a different field of business in some way, and so therefore they can't prove that there's been a loss of sales or a loss of royalties. Well, what then? The answer then is that the claimant will be entitled to a reasonable royalty for the use of the intellectual property right in question. And a reasonable royalty is assessed as what would have been agreed between a willing licensee and a willing licensor. And if there are comparable licenses between third parties that are available, then that will typically be taken as a yardstick. So one of the things you will be looking for in that third type of case is to see, is there evidence of similar intellectual property rights being licensed for similar kinds of business activity? What kind of royalty rates do we typically find in those kind of licenses? And we'll then use that as a basis for assessing what a reasonable royalty would be. So those are the three basic ways of assessing damages. Now, although that gives you the basic structure, when you get into assessment of damages in intellectual property cases, it often turns out that things are a little more complicated. And there are various different types of complexity that you have. I'm just going to mention a few. First one that I will mention is a claim for lost profits. So this is the first method of assessment I told you about. We've got a claimant, intellectual property right holder, that is exploiting the intellectual property right by manufacturing and supplying goods. They've lost sales, they're claiming lost profits. So what you find sometimes in that kind of case is a claim for what's called convoy goods. This is an American expression, but it's quite a handy label for what we're talking about. Convoy goods are goods which are not themselves protected by the IP right in question, but which are sold together with protected goods. So the classic example is where you've got a protected item and then there are spares and consumables. So imagine, for example, to use some old-fashioned technology, we're talking about a photocopier. And there's something patented about the photocopier, and the patentee sells photocopiers, but they also sell spares for the photocopier, and they also sell printer cartridges to go in the photocopiers. And they can show that as well as losing sales of the photocopiers by reason of the infringement, they've also lost sales of the spare parts and they've lost sales of the consumables like the printer cartridges. These are convoy goods. And in principle, even though the patent doesn't protect the spares and the consumables per se, you can have a claim for lost sales, lost profits on those other goods. But it's a question of causation. So what has to be proved in such a case is that the reason why the claimant has lost the sales of the spares and the consumables is because of the sales of the infringing product and not for some other reason. So you have to look quite carefully at the evidence to see, does it establish causation? Another example, also on a claim for lost profits, is that you may have a situation where the claimant says, well, I've lost some sales as a result of the infringer, but also even on the sales that I managed to keep despite the infringement, in order to keep those sales, I had to reduce the price that I'm charging. Because the existence of the infringing goods in the market forced me to lower my price. And a typical example of that is the scenario of patented pharmaceutical products. So if you've got a period of infringing activity, you will often find that what the originator has had to do, the supplier of the patented goods has had to do during the period of the infringement, is they've had to reduce their prices in order to keep competitive with the infringing goods. And so what they will do is they will come to the court and say, we claim first X pounds for the lost profits on the lost sales, where we couldn't match the infringer's price, but also we claim Y pounds for the price suppression as a result of the infringing activity, even on the sales that we did manage to keep on making. Another kind of complexity that you can have in these cases is parallel claims by the owner of the intellectual property right and an exclusive licensee. In many areas of intellectual property, as I said to you before, the commercial method of exploitation is through licensing, and licensing may be exclusive or non-exclusive. So if it's exclusive, it's just the one licensee to the exclusion of everybody else. If it's non-exclusive, then you may have licenses granted in parallel to a number of different parties to exploit the intellectual property right in question. And the basic system under our law is that if it's an exclusive license, then the exclusive licensee has a right of action to claim for infringement in parallel with the owner of the intellectual property right. So in such a case, you may have parallel claims by both the owner of the intellectual property right and by the exclusive licensee. And typically in that kind of case, when you get to the stage of assessing damages, you will have a claim by the exclusive licensee, who is the party that's actually carrying on the exploitation of the intellectual property right, for lost profits, and then a claim for lost royalties by the IP right owner, because of course normally the exclusive license will provide for the licensee to pay royalties to the right owner, and therefore if the licensee loses sales, it follows that the IP right owner loses royalties. An important point to bear in mind when it comes to assessing damages is that under our case law, it's well established that in general it is simply irrelevant to ask how easily the defendant could have adopted a non-infringing alternative. And even though that's well established, it's still quite common to find defendants in these kinds of cases arguing that, well, the claimant can't really have lost that much because I could easily have adopted a non-infringing alternative, and then the claimant would have lost exactly the same number of sales and exactly the same amount of profits. To which the answer is tough. You didn't adopt the non-infringing alternative, therefore you must pay. That's the price of infringement. Now, another aspect to bear in mind is that although the basic principle under our law is that damages are compensatory, there are various types of damages that can be claimed which go beyond the compensatory. And in the terminology used in English law, these are referred to as exemplary, aggravated, and additional damages. So what are exemplary damages? Well, this is a label for what are more usually known under most systems of law as punitive damages. And these are, generally speaking, not available in IP cases. You may know that there was a case before the Court of Justice about 3 years ago about a system of double or treble damages in Poland. And one of the things that we await to find out definitively from the Court of Justice is the extent to which punitive damages are prohibited as a matter of European law. In that case, the Court of Justice said that double damages were not contrary to European law. Whether punitive damages will turn out to be prohibited is not entirely clear from the judgment because it wasn't really necessary for the court to say. So I think that's a question of watching this space. But certainly under English law, there are very, very few situations where you would have any arguable case for punitive damages, and so in reality you can ignore it. What is more realistic in terms of a claim is what we call aggravated damages. So aggravated damages are compensatory damages, but with an extra element to compensate the claimant for things like hurt feelings. And this is what corresponds in the terminology of the IP Enforcement Directive to moral damages. This is an expression that derives from the French. I can't remember what the original French is, but it's translated in the English version of the IP Enforcement Directive into the term moral damages, which is not phraseology that in England we recognise, but we understand that when it refers to moral damages, it's talking about what we would call aggravated damages. And this kind of situation can be particularly relevant in copyright cases, for example. And the reason for that is that there are certain types of copyright cases where there's an element of infringement of privacy. So a classic example is revenge pornography. Okay, so this is this very unpleasant situation where men in particular post on the internet images of former partners of theirs who are naked, in order to inflict revenge upon them for having split up the relationship. Very nasty. But frequently, it turns out that there's a copyright claim. This may be one of the simplest ways of doing it. I mean, we've now made it a criminal offence, but it can be quite tricky to prosecute. But one way of dealing with it is through the copyright system, in particular, because, of course, one of the things that the woman wants to do is to take down the images from the internet. And that often can be most easily done through the copyright system. But if you bring a claim for infringement of copyright in a case like that, of course, it's not so much about any kind of financial remedy, it's invasion of privacy. And that's a classic kind of case where you might have a claim for aggravated damages because it's all about the hurt feelings that the woman has suffered through the invasion of her privacy. Even though she bases her claim on the fact that originally the source of the photograph was her own selfie, which she then sent to the defendant. So that's just an example, and there are other kinds of scenarios where that kind of thing can apply. Additional damages are a specific statutory remedy that we have under our Copyright Act for infringement of copyright and related rights. The same thing applies, for example, to performers' rights. And these enable damages to be awarded for flagrancy, in particular, that go beyond strictly compensatory damages and may be regarded as analogous to aggravated damages. So this is not so much a case of hurt feelings, perhaps, but where there may be some evidence of some additional damage to the right owner going beyond those which you can quantify in terms of lost sales or lost royalties. So you can have an enhancement of the damages award in that kind of scenario. And, for example, a situation where there's been some damage to the reputation of the right owner in a financial sense rather than in a privacy sense. And then you might have an award of additional damages. And the jurisprudence of our court so far is that Article 13 of the IP Enforcement Directive has potentially been interpreted as potentially enabling the court to award additional damages for infringements of other IP rights like patents, trademarks, and so on. But so far, no such award has actually been made. Okay, let's turn and look at the other remedy, which is the account of profits. And again, the basic principle is clear and simply stated, as I said to you earlier. It is that the claimant is entitled to restitution of the profits made by the infringer as a result of the infringement. However, the problem with this remedy is that experience shows that calculating the profits that have been made by an infringer can be actually quite difficult. So in calculating the profits that the infringer has made, of course, a very important question is what costs the infringer has sustained. It's generally speaking quite easy to calculate the gross revenue, and the defendant will have been required to disclose that before the claimant makes its election. I told you that the defendant must disclose at the outset how many sales have been made and what sums of money are received or receivable. So you know quite quickly what the gross revenue is. But then you have to say, well, what costs can be deducted? And that's when you get into matters of accountancy, and it gets very complicated. Because what you soon find out is that it depends on things like whether the defendant was making other non-infringing products, whether they have spare capacity in their factory, and things like that. Because the basic principle is to say, well, the defendant can incur costs that were directly attributable to the infringement, but cannot deduct costs that it would have had to incur anyway. So if, for example, they would have employed the same number of employees, then that's a cost that they would have had to incur anyway. That cost is not attributable to the infringement, therefore it cannot be deducted. But you get into a lot of argument about the counterfactual scenario, because of course you know what happened in fact about what the defendant did, but you have to hypothesize the counterfactual where they didn't infringe and therefore didn't make the infringing product. What would have happened then? And so you get into this complicated exercise of trying to work out what they would have done by way of manufacturing or supplying, and what costs they would have incurred in the counterfactual scenario. And it soon gets quite complicated. Another problem you get with accounts of profits is that it may be necessary to apportion the profits, and this classically arises in situations where you've got an infringement of an intellectual property right which is relevant only to a part of what the defendant is selling. So the example I've given on the slide, simple example, is the defendant is making and selling cars, automobiles, but the infringement concerns a patent, let's just say, for an improved heating system in the car. Well, obviously the car is an expensive item, but what part of the defendant's profit on selling the car is attributable to the fact that it has an improved heating system. And as you can readily appreciate, try to figure that out can be very difficult. So the reality is that although conceptually simple, calculating an account of profits turns out to be very difficult when you actually try and do it in practice. And for this reason, it is actually a remedy that is not frequently opted for by claimants. Usually they go for damages. It's quite unusual to go for an account of profits, although they do it in some cases. But in this context as well, it is generally irrelevant to us what profits the defendant would have made had it adopted a non-infringing alternative, although there's an element of it in when you look at the counterfactual scenario in terms of looking at deductions. So that it's not, the defendant can't claim simply that they would have lost, that they would have made the same profits if they'd not been an infringer, but it does become relevant in terms of the deductibility of costs. So as I say, it's quite a complicated exercise in actual reality. So let's talk a little bit more about some of the procedural and evidential issues that these kinds of claims give rise to. Now, the first point to note is that under our procedure, it is usually the case that an inquiry as to damages or an account of profits will take place after there's been a decision on liability. So the first stage of the proceedings will be just to determine, is the intellectual property right valid and infringed? Because if the answer to that question is no, then you don't go on to consider the financial remedy. There's no need to do so, and it would be a waste of time and money. And under our procedure, the second stage of looking into damages or profits is technically part of the same proceedings. So it's identified by the same case number in the court, but as a matter of practical reality, it's a second stage of the proceedings. So you go through all the same stages that you went through for the first stage. So you would have a statement of case from each party setting out what their case is. You have disclosure of documents. You have exchanges of witness statements and experts' reports. And then you go to a trial with cross-examination of the witnesses. And just as you have all of those stages to establish liability, you go through exactly the same stages to establish the amount of the financial remedy. So you have a second trial, even though it's technically part of the same proceedings. Now, a key step in any form of claim for financial remedies, whether you're talking about damages or profits, is disclosure. And as you're well aware, under the English system, we regard disclosure as a vital tool for doing justice, even though we are well aware of the fact that it's expensive, and we're constantly battling with the question of how to make maximum utility of this tool while keeping costs under control, which is a difficult thing to do, but we're working hard on it. It's particularly important when in this kind of scenario, because as soon as you get into any question of damages or an account of profits, the financial information from the parties is absolutely crucial. You can't calculate damages or profits without proper financial information from the parties. So getting disclosure of the financial information is absolutely critical. And as a very simple rule of thumb, on an inquiry as to damages, the key financial information that the parties are arguing about is usually the financial information coming from the claimant, because it'll be the claimant's manufacturing revenues, the claimant's costs and their profits on their manufacturing, or their lost or their license income if they are exploiting by licensing. On an account of profits, the key financial information usually comes from the defendant. It's revenues that the defendant has gained from the infringement, the costs that they are trying to deduct, and the profits. So you need the disclosure of all this financial information from the parties in order to be able to calculate the appropriate amount. And in England, in cases of any complexity, it is usual for both parties to adduce expert evidence from forensic accountants. There are people in my country whose business it is to give evidence of this kind. And they are extremely used to analysing financial information of this sort and calculating damages and profits. But of course, inevitably what you get is different views from the opposing experts. Now, some people say that's a problem. I'd say not so. As always, it's useful for the court to have different views from people who are expert in the field, because by the clash of opinions, you can arrive at what is a fair answer. But it has to be said, again, it does add to the expense. You may also need factual evidence as well as expert evidence from forensic accountants. For example, factual evidence to discuss the question of causation. What sales have been lost by the IP right owner, or what royalties have lost, and so on. So you may well need factual evidence as well as expert evidence. Burden and standard of proof. Well, in general, the burden of proof will be upon the claimant, but the burden of proof on specific issues may nevertheless lie upon the defendant. And the example I've given on the slide is in an account of profits. When it comes to deduction of costs, the burden of proving that the costs are properly deductible lies on the defendant. So that's an example of a specific issue where the burden of proof may lie on the defendant, even though in general terms the burden of proof is on the claimant. And so far as the standard of proof is concerned, in general, that will be our normal civil standard, which is the balance of probabilities, as opposed to our normal criminal standard, which is beyond reasonable doubt. So all the claimant has to do is to prove the damages or the profits or on the balance of probabilities. Likewise, if it's the defendant showing what costs are properly deductible, something like that. Balance of probabilities. One thing that is relevant to bear in mind, though, is that the court can draw adverse inferences in certain circumstances, in particular if it turns out that the defendant has destroyed or failed to disclose documents or other evidence that show the extent of the infringing activity or the profits that have been made as a result. And in those circumstances, we don't let the defendant simply get away with that. We draw an adverse inference against them. Another factor that is relevant to bear in mind at this stage is interest, because, of course, court proceedings take time. Even if there's been a preliminary injunction, there may have been a period of infringing activity, and you come to court later. And, of course, justice is delayed is justice denied. And one of the tools at the court's disposal to deal with that is to award interest to reflect the fact that time has elapsed since the infringing activity took place. And so the claimant will be entitled to interest on damages. In the case of an account of profits, there's no automatic entitlement to interest, but it is usually awarded for the same reason. And the normal way in which we approach interest questions is to award simple interest from the date of infringement at a rate which reflects the rate at which the claimant would have had to pay had it borrowed the amount of money in question as which has been awarded as damages or profits. And there may be specific evidence from the claimant as to what their borrowing costs have been, but in the absence of specific evidence, then the court will order a conventional rate which varies over time. Typically, historically, it's been base rate plus 1 or 2%. Now, another factor in the equation in terms of the practicalities of all of this is something that Michael Feisch was telling you about yesterday, which is costs. When I'm talking about costs, I'm talking about legal costs. So this is what parties spend on their lawyers and on their expert witnesses in particular. And you will have appreciated from what I've said to you already that inquiries as to damages and accounts of profits are quite costly in terms of the legal fees that are required and the expert witness fees. And so, therefore, in practical terms, an important issue is the incidence of costs. Who pays? And as you will have gathered, under the English system, we have what we call cost shifting, which is to say, as a basic principle, the loser pays the winner's costs. So if you lose in litigation, then you pay, broadly speaking, the costs that the winning party has sustained. There are various qualifications to that basic principle, but that is the basic principle. How does that basic principle operate when we're talking about financial remedies? Well, the answer is it all depends what offer the defendant has made. If the defendant has offered to pay nothing, then if the claimant recovers something, then the claimant will be the winner and will be entitled to its general costs, although you could have a deduction from that if there are specific issues on which it is lost. So maybe if it's lost on a couple of issues, you might say that the claimant will get 80% of its costs to reflect the extent to which it is the successful party. But of course, that's not what usually happens. What usually happens is that the defendant knows it has to pay something, so it doesn't offer nothing, and usually the defendant will pay a certain amount of money into court. And what will then happen is that whether the claimant gets the costs or not depends on whether it's awarded more than what the claimant has paid into court. So if the defendant pays £1,000 into court, the question is, does the claimant get more than £1,000? If it does, then it's the winner and it will get its costs. If it gets less than the defendant has paid into court, or even the same amount, then the claimant is the loser because they haven't done any better than the payment into court, and therefore the claimant will pay the defendant's costs. And obviously, the judge who's deciding on the amount can't know how much has been paid into court, and so the rules of court provide for the judge not to know that until you get to the stage of the argument about costs. So the judge is blindfolded up to that point so as not to be biased, but then the blindfold is taken off and you then just are in a position to see who is the winner for the purposes of deciding costs. And as a matter of practical reality, because of the expense of litigating liability, the fact that often for most rights owners in IP, the most important remedy is the injunction which they get to stop the infringing activity if they are successful, and the expense of an inquiry as to damages or accounts of profits, what usually happens is that claims for financial remedies are settled between the parties, compromised outside court. And therefore, our case law in terms of actual awards of damages or profits is relatively sparse. One of the interesting things that's happened in our jurisdiction in recent years is that paradoxically, you might think, we've had more cases on damages and accounts of profits since what was the Patents County Court was reformed into the Intellectual Property Enterprise Court. And the purpose of that reform was to make access to justice more accessible to small and medium-sized enterprises in intellectual property cases. As Michael was explaining to you yesterday, not only is litigation generally expensive in England, we've had a particular problem going back many, many years with the expense of IP litigation. And there was a lot of evidence to show that small and medium-sized enterprises were being simply priced out of the system by the costs involved. And the Patents County Court was an initial attempt to solve that, wasn't entirely successful, and so it was reformed and changed into the Intellectual Property Enterprise Court. And that has been more successful in providing access to justice for SMEs. I'm not going to pretend to you it's a complete panacea, but the evidence is clear that it has provided more access to justice because it has a much higher caseload than the Patents County Court ever had. And so we can see that cases are now being litigated in the IPEC that were previously simply not being litigated. And one of the things that's happened as a result of that is that it's turned out, paradoxically, that we've had more claims for damages and accounts of profits actually going through to a dispute and a court decision in the IPEC than in our normal civil procedures. Why is that? Answer, because when we reformed the Patents County Court into IPEC, we deliberately provided for a streamlined procedure that was designed to be lower cost. And what this has meant is that a number of parties have found it worth their while to go through to a contested hearing on damages or profits in IPEC, even though in our ordinary civil procedure they wouldn't have found it worth their while. And so we've had a few decisions coming out of IPEC on damages and accounts of profits, which have significantly added to our case law in this area. So an interesting result, which, speaking as the person who is primarily responsible for designing the reforms to IPEC and getting them through the government machine, I certainly did not anticipate that outcome, but it's been one of the surprising benefits. So there we go, that's an overview. Any questions? Yes.
Thank you very much for excellent presentation. I have actually some questions. First one is related to action right, and the question is whether a non-exclusive licensee could have an action right in your system or not, or just exclusive license.
So the answer to that is not entirely straightforward. In general, a non-exclusive licensee does not have a right of action, but there are certain specific circumstances in which it can do so. So, and it depends upon which intellectual property rights you're talking about. So I would have to look this up to give you an entirely accurate answer, but from memory, I think it's for trademarks. There's a provision that says that it's either trademarks or copyright, I forget which. But for one of the IP rights, there's a specific provision that allows a non-exclusive licensee to bring a claim if specifically authorized to do so by the owner of the right. So the non-exclusive licensee has to be authorized by the right owner to bring the claim.
Thank you very much for that. And next question is about reasonable royalty. Could it be awarded in case when the right owner actually does not issue licenses in normal course?
That's the case where it is, yes. If there's licensing, then you just apply whatever is the standard rate.
But if he doesn't issue licenses, or it is obvious he would not be willing to issue a license, let's say in copyright case, when it's when the work used which he doesn't even want to disseminate to public, would in that case, when there is infringement, he could ask for reasonable royalty?
Absolutely right. So it is generally speaking the case that most intellectual property right owners would never have agreed to license the defendant to do what they are doing. So if it's a patent case with a true monopoly, frequently the patent owner would never have granted a license, the whole point being that they want to exploit their monopoly and get the monopoly profits. Even if it's not a true monopoly like a trademark case or some copyright cases, it's frequently the case that the IP right owner would not have licensed that particular defendant to do what that defendant did. They might have licensed someone else to do something different, but not that defendant to do that activity. But when it comes to the assessment of a reasonable royalty, that's not relevant. because what that simply tells you is that the defendant is an infringer. In terms of assessing the royalty, you have to hypothesize that you have a willing licensor and a willing licensee, and to imagine what they would have agreed. Now, of course, everybody knows that that's a somewhat artificial exercise in circumstances where, in reality, the parties are daggers drawn and they would never have agreed anything. But the court has to hypothesize what the parties would have agreed if they'd both been willing and reasonable.
Yeah, I do understand, but actually I meant the case more when it's clear that he wouldn't not license not just defendant but anybody else. We have had case where some photos were stolen actually from private archive of the person, of the author, and it's clear that this author wouldn't license to anybody. Would that be possible? I know in a German system they would say you may not apply license, this reasonable royalty rule.
We don't regard that as in any way a problem. That the fact that, as a matter of reality, the copyright owner wanted to keep the work private and not publish it doesn't prevent him from claiming a reasonable royalty. And you would then ask, well, what's the reasons for the copyright owner wanting to keep it work private? And it may be that, for example, let's suppose the copyright owner is an author or a composer, and he thinks, well, I've written this piece of literature or music, but it's below my usual standards, and therefore I don't want to publish it. Nevertheless, you could still hypothesize what would have been the financial consequences if it had been published and assess that by way of a reasonable royalty. But maybe the reason is it's more a privacy issue, like the case of the revenge pornography that I gave you. Now, in those circumstances, it's not really about financial consequences, it's about reputational consequences, hurt feelings, and so on. And in that kind of a case, you're looking rather less at what a reasonable royalty would be, and more about the aggravated or additional damages. I mean, the court might still award a reasonable royalty to the extent that there's some kind of financial consequence. But in that kind of a case, it's not really about the financial consequences.
I limit myself to the last question because I have more, but I was going to ask them maybe in coffee break, if I may. But the last question from my side also about license fees, about reasonable royalty. Let's say if there is an infringing period is of about 2 years' time, and normally a right owner issue a license for 5 years. Would you award this damages or this reasonable royalty for a 5-year period, or just calculate for 2 years, proportional to the cost?
So it depends. The mere fact that the license would normally be granted for 5 years would not be sufficient to justify a claim for 5 years if the infringing activity only took place for 2 years. Because you can only claim for the damage that's been sustained. And if the infringing activity is only taking place for 2 years, then prima facie, that's the limit of the claim. However, there are two qualifications to that. The first is the question of causation. Because if the claimant can somehow prove that he's really lost the opportunity of a 5-year license through 2 years of infringing activity, then he could claim for the 5 years. But he has to prove that as a matter of causation, and that's typically going to be quite tricky. But then the second qualification is much more usual and relevant, which is that what the claimant says is, well, never mind how long my license period normally is, I've suffered ongoing damage as a result of the 2 years of infringement. So typically the scenario that's postulated is, let's say we've got a patented pharmaceutical, and the patentee has had to reduce its prices for the 2 years of infringement. So that's straightforward. But then what the patentee says, well, as a matter of practical reality, I could not put my prices up at the end of the 2-year period because having reduced them for 2 years, no one was going to pay the differential. And so I had to carry on reducing my prices even though the infringing activity has stopped. And then you get into a different question, which is one of accountancy, which is how you model that in financial terms. And accountants have a model for doing that, which is called the discounted cash flow, or DCF. And the whole point of the DCF calculation is to allow you to calculate the present value of future income streams, or indeed future losses. And so you can calculate as a matter of accountancy what that's worth. And basically, in simple terms, it involves a tapering down over time. And there are ways in which the forensic accountants model that kind of a loss over time. Because eventually, of course, over time, the value of getting the money now outweighs the future loss.
Thank you so much. Actually, I also have questions, and maybe probably someone else has any questions, but this is a broad topic, and now it is time for coffee break. So my suggestion would be that after coffee break, we have Mr. Dillon's lecture, and then we have another one of yours. If you don't mind, maybe taking first 5-10 minutes still talking about damages and answering maybe a couple of questions, and then if we could proceed like that.
Sure, or I could, if you've got a burning question now that I could have a quick answer to.
I don't think it will be so quick. It's at least 3 questions.
Oh, all right.
Okay, just one small question. What do you do if there is not enough of proof to calculate anything? The claimant has not worked good enough, or the defendant is just not there. He's somewhere lost in China or somewhere else, and you do not have enough of information. Do you give some rough and ready lump sum of something, or you give nothing, especially if it is claimant's fault because he hasn't submitted what he actually could have submitted and has not given you anything to calculate properly?
Yeah, so in the absence of proper financial information, the court will do its best to make an estimate. But as you rightly imply, in making the estimate, you will take into account who's at fault for failing to provide the proper financial information. And if the claimant is at fault, then you will err on the low side. And if the defendant is at fault, you'll err on the high side.
Right. And if, for example, he asks for a method that could definitely not give him any remuneration. Let's say he goes for account of profits, and actually it turns out after calculations that he cannot get anything. But there was some lost sales, and actually there is some evidence in the case. He cannot flip, or the judge could not give that instead, or can
well,
you?
You hit upon an issue which is still controversial, so I can't tell you what the definitive answer is. The general thinking, I think, is that once you've made your election, you can't then change your mind at a later stage if it turns out you made the wrong choice. However, I'm aware of the fact that there have been cases where people have argued to the contrary and said, well, we should be allowed to change our mind. And I don't think that any definitive answer has been given to the question of whether, and if so, in what circumstances, the claimant should be allowed to change their mind later. Currently, as I say, the general assumption is no, you can't.
But the judge is not obliged to switch to another remedy, let's say.
Certainly not. No. The question would be if the claimant asks.
Thank you so much. Yes.
Ladies and gentlemen, a very short comment. Richard has eloquently and clearly explained you the question of all the questions of damages. I touched on this yesterday and made a nasty remark upon the profession of the forensic accountant. Now you see, ladies and gentlemen, just how complicated the calculation of damages can be. So, 1, mediation is always possible, And two, remember that the forensic accountant's bill is usually more than the patent agent's bill.
Thank you, Judge Feij, for this remark, but we have to deal with stubborn parties as well. Okay, thank you. So it is a coffee break now till 11:10. Kafijas pauze līdz 11:10.